Hello, everybody. We come to the concluding session of this beautiful conference, and I invite Professor Helland to and Professor Chodosh and Shimon Shetreet to open the discussion. Do I see Professor Helland?
Andrea,
Yes.
Professor Helland and Professor Chodosh are not on the screen.
Okay.
So I will present, with your permission, the
Please.
proposal for the amendment of the Mount Scopus Standards, Article 1.3a. We distributed, as you saw, Mr. Chairman, the text of the amendment and the explanatory note. I only have one comment from Professor Chodosh, which I will explain. May I begin while they are putting it on the screen? As you all remember, Article 1.3 of the Mount Scopus Standards recognize the need for respect of domestic fundamental principles by international tribunals. This article was approved as an amendment of the JIWP standards in Vienna in 2011. Article 1.3 reads as follows. I'm reading it. It is vital that supranational and international tribunals respect the fundamental principles of the legal systems of the member states, and to that end acknowledge the collegiality of the traditions of the courts of both the municipal and extra-municipal courts. I would like to mention that this text was adopted after quite protracted and long discussions at Vienna with the assistance of the late Professor Sir Louis, who was a very, very important person with us, Professor Blum Cooper, and this is the text that we adopted. Now, it is now necessary to review an amendment which will address the challenge of balancing between universal standards and, on the one hand, and particular circumstances of domestic jurisdictions on the other. The proposal is to add 1.3a to the text of the Mount Scopus Standards, which will guide the considerations of what we call universality versus particularity. So what is the text? On the screen, you have the text, and the text reads as follows. The task of creating international standards requires taking into account not only judicial independence, but also the other fundamental values of the justice system, such as accountability, efficiency, accessibility, and public confidence. Section B of this article proposed a central challenge of drafting international standards of judicial independence is to formulate the standards which will reflect the values of universal desired standards. At the same time, the standards must take into account the particular circumstances of the domestic jurisdictions and the different legal cultures and traditions in the various countries. This challenge is met by careful deliberation. It is proposed that in order to properly analyze compliance with judicial independence in matters of judicial process, judicial terms, we must consider two main approaches, universality and particularity. Universal theory or universality holds that an independent judiciary is necessarily a shared value of all legal systems essential to the rule of law. Universality calls for defining a universal model of judicial independence reflected in legal rules and other formal institutional arrangements, including judicial appointments process and the rules of appointment, review, retention, and recall of judges. D, alongside the universality approach, we must take into account circumstances in each jurisdiction and recognize that in some countries it is justified to exempt certain practices from the universal standards. This is what we call the approach of particularity. The universality and particularity rule should be qualified so as not to accept legislation of or judicial decisions or administrative decisions when carefully examined are predominantly motivated by improper aims. Measures taken by government in countries that change the system of government, I don't think we should mention Europe. This is the comment made by Professor Chodush, as the legislation and court decision in the new democracies in Europe. But we can, if we accept the comment of Professor Chodush, we can just say in court decisions, in the situation of changing of government rule, must meet the test of predominantly valid aim to prevent actions with predominant improper aims. That means we are talking about predominantly aimed to interfere with the judiciary. Similarly, last section, in all democracies, therefore, we have to say in normal situations, that is not necessarily in a situation of a change of government, of a system like from communist to democratic, if such predominant improper aims can be shown in the use of long-established practices to the detriment of judges and judicial independence, such measures should be equally declared as being in violation of judicial independence. Being an old democracy or having a long-established practice cannot be a shield from an adverse judgment regarding actions of the legislature, of the executive or judicial branch that violate judicial independence. So this is the proposed amendment for this session, for this conference of the Mount Scopus Standards of Judicial Independence. And Andrea, Mr. Chairman, if we have already comments, we should take them. And if not, I'm ready to give the explanation which is on the board, but I think we can now switch back to the normal screen so that people can make comments without being covered by the screen.
Are there comments or questions? I ask this to the public or to people who are on screen.
Shimon,
Entin, yes.
did Hiram Shadash explain why he made his comment about taking out that reference to the former communist countries?
What is the current text? We don't have any text on this issue. We just have this statement in 1.3.
No, I'm talking about in the 1.3 AF, Hiram suggested that we take out the reference
It
to,
suggested not to refer to the situation in Europe, but to put it in a more general way. That is, when there is a change of a government or a system of government, without referring to new democracies and old democracies in Europe, even though in Europe it is a central issue in the general discourse on this subject. But since we are at international standards, this could go to the commentary. It doesn't have to be part of the text.
no, I'm fine. I'm fine with that. I just wasn't sure from the earlier presentation what the basis for the comment was. I'm fine with that. So
You're fine with the text, including the reference?
no, I'm
including
fine
the reference?
with Hiram's suggestion.
Okay, so you suggest to accept
Yes.
the suggestion of Hiram. Okay.
Right. I just
think-
wanted to
I
get
think it is-
his sense about,
The idea remains the same,
right.
except we put the example of the new democracies and old democracies. We put it in the commentary, but in the text itself, the text itself would be general. That is, it would say as follows: measures taken. I'm talking about F, section F. Measures taken by government in countries in case of change of system of government, okay, without the words such as the legislation and court decision in the new democracies in Europe, okay? These words will be omitted, and then will be which changed. No, it will be until rule. From the word such until the word rule, all will be omitted and transferred to the commentary. So it will read measures taken by government in countries that change the system of government. Measures must meet the test of predominantly valid aims to prevent actions with predominant improper aims. And the same thing for G. Similarly, even in democracies that have not changed the system of government, and then we take if, and we take from the word if until the word judicial independence in the second line, and it will read as follows. Similarly, in all countries, such measures should be equally declared as being in violation of judicial independence. Okay, being long-established practice, long-established countries, in ordinary countries, should be equally declared as being in violation of judicial independence. Okay, now having a long-established country practice cannot be a shield from adverse judgment. Okay. So we accept the suggestion of Hiram. Any other suggestions?
Is this the only point which Professor Chodosh was named? You mentioned a paper or some comments he made. Is this the important point, or are there other things? Because I would like to know clearly if we now amend this change, or if we postpone it, what I propose, to the next to the next session in Claremont, to really to finalize this.
What do we suggest, to go ahead and approve it, or should we?
I'm not happy to say the truth. Shimon, you're a specialist to bring up these things in a last moment, which I can understand, because there was a huge work to do to prepare and so on. But I mean, I don't know how many people we are now here to. Of course, you the most important.
So what do you suggest, to approve it in Claremont and not
Yes,
today?
yes. This I.
No, I suggest the following. To
Tell me.
we sent it to the membership, and we will ask them. We give them the report that we discussed it today, and it was amended. That means the proposal was amended to take into account Hiram Chodush's suggestion. Will open the new version for comment, and we can decide to approve it after 1 month.
Okay.
When it is open for comments. What do you think?
Yes, this is a good proposition. I can live with it.
Now, the next item in the agenda, just to update you that Hiram and Eric Helland are organizing a continuation conference in Claremont in the autumn, in the fall of this year. So they will be giving us the details and inviting our membership to come and to continue our discussions on this general topic of measuring justice. So this is one update that I'm giving you on behalf of Hiram and Eric Helland. This is the update before when the chairman would allow me to make some concluding comments. We come to an end of our conference. This is the concluding session. I want to thank every speaker who invested so much effort to give time to prepare the presentation. I want to thank all the chairmen, the chairperson, who conducted the proceedings and the sessions in a very, very disciplined way, to allow all the people to make the presentations within the limit that was set to them. I would like to thank the Hebrew University and the Faculty of Law. I would like to thank the Claremont McKenna College and the president and our good friend and colleague, Professor Hiram Chodush, and Professor Eric Helland. And I would like to thank the Israeli Bar Association. I would like to thank our team, our production team, headed by Ohad Halevi, and my team, my assistants, Zahava Saar, who helped us very much, including keeping contact with all of you, all the speakers. And I would like also to thank the translators in the relevant sessions. We apologize for one of the sessions that was conducted in Hebrew, and there was some clerical problem. So we thank them for the work that they did. Here I'm seeing a chat from Anthony, from Anton Kure. Special thank you to the technical team for uninterrupted streaming of the high quality. So you have the gratitude of our members. They are raising their hands in gratitude, and they are clapping hands in gratitude, and rightly so. Thank you, Anton, for making this point. So I think our decision to hold this conference on a hybrid model was a good decision. The fact of the matter that we were successful in having about 60 speakers in the 3 days of the conference is an evidence that it was a correct decision. I remind you all that we expect to have your papers for volume number 6 of our book series on judicial independence. Let's say in 6 months, we will write to you to get the papers when they are styled for an article to be included in the book. I also mentioned to you that we sent you in the mail a coupon to buy the previous volumes with a discount of 25%. Since the price is quite high, 25% is a good discount. And Anton is also wishing you Mazal Tov and appreciation. Thank you, Anton, for you are very versatile in using the chat in the Zoom and the streaming, almost like my students, who are very proficient in the digital culture. So, and I thank very much. This is an opportunity to thank our General Secretary, Andrea, who is doing the work of keeping the legalities of our association, Andrea Danuser, and this is the opportunity to thank him for his work and for his attention to all the legalities that are required by keeping our association in a proper way. I remind you that we have a website with all the information and about our projects, the New Delhi, the Montreal, the Mount Scopus, all the conferences are included. We will now add updates on this conference that was held here in Jerusalem. And so we are, in fact, now closing a historical cycle from 1981, Mount Scopus first conference that drafted the code that was approved in New Delhi. And now, after so many years of an additional standards that we drafted, the Mount Scopus standards revised in 2008, and over the years made so many additions and amendments. Now we are here again in the year of 2022. We still call it 40 years because, like the Olympics game of 2021, they were called 2020. So that's why we call it 40 years, honoring our pursuit of judicial independence for so many years, for 4 decades, with the help of so many people. This is Asher who said Mazal Tov. Thank you, Asher. I want to say that the effort that we have invested over 4 decades is collective effort with so many contributions by all the membership of our association and all the active members who organized and hosted the conferences until now have made active contribution to the work that promoted the study, the research, and the protection of judicial independence around the world. Thank you, Chairman.
Thank you, Shimon. Now, if there are no other votes, I will close this last session, and I wish everybody a safe return home and hope to see you in Claremont in the fall, or personally in person, or by video stream. So, thank you.
Thank you very much, and Happy New Year.